Thank you everybody for coming. Before we get started with the broadcast, I just wanted to give some quick housekeeping instructions, fairly standard. Everyone here will be muted or is muted, and so if you have a question, please feel free to enter the question in the chat. I'll try and monitor it as we move forward, and then I hope to have a pretty robust question and answer session at the end. I think this is a good opportunity to get sort of some experts on this subject to weigh in on some issues. So hopefully you'll take advantage of that. If anybody's here looking for either CE credits or CLE credits, we have put a link to the course evaluation and credit request form in the chat. So fill that out, hit submit, and then we'll be in touch with your certifications. So I want to turn now, introduce our panelists to weigh in on these issues. The first is Jason Cabrera. He's a member at Cozen O'Connor, specializing in labor and employment law. Jason routinely advises companies on their obligations under various federal and state laws, and he often defends companies from claims filed by employees and former employees. Jason will help give us an overview of the legal landscape and some common situations that employers across the country are facing on this issue. Then we'll hear from our own Mark Troxel. Mark has been with the Graham Company for 24 years. Mark heads up our safety services team and is responsible for the safety services that we provide. Mark has been involved in setting up drug and alcohol testing programs since 2004. I think he's a wealth of knowledge in the OSIP space, particularly on this issue, and hopefully you'll learn a lot from his boots on the ground experience, so to speak. Then we have Marty Ann Martins. She's been in the field of occupational health for 16 years. She's worked with companies of all sizes across the country to assist in setting up company drug and alcohol testing programs. She specializes in DOT drug and alcohol programs and helping employers through the setup process. Marty Ann has a wealth of information about testing, and so hopefully I learned a lot, so hopefully you all will too. So in this program, we're going to give, like I highlighted, a little bit of an overview of the ever-evolving legal landscape in this space. It is hard to keep track of. Luckily, we have Jason here with us to help us out. He will give us an overview of both the medical and recreational marijuana use legislation across the country. Then we'll move to some employment-related issues, which mostly what everyone's here for, that arises out of this issue now. How do we deal with this across your organization's employee populations? Then we'll hear from Mark and Marty Ann about permissible drug testing, methods, timing, options, costs, all of that, and I encourage you again to use the chat feature. And then we'll talk about what do you do from here, sort of what are some best practices, how do you work with outside counsel to develop your own organization's drug-free work policy or drug and alcohol policy, and whether or not a drug-free workplace policy is possible in these times. So I am going to kick it off and throw it over to Jason to help clear this area up. It's clear as mud to me, but looking to Jason for some guidance.
Well, Krista, thank you very much. Good afternoon, everyone. It's a pleasure to be with you all. There is a lot to cover, so we will dive in, but of course, if anyone has questions along the way, use that chat feature as well. So the first step up in terms of talking about the legal landscape is the law that we all know, which is the federal ban on marijuana. Marijuana is still in Schedule 1 of the Federal Controlled Substances Act, which means that mere possession of it is a federal crime. That is the law. It's been the law for a very long time, and a lot of the issues that we're dealing with stem from the fact that states are changing their laws, but the federal government, at least heretofore, has not done so. There is one aspect of this federal ban that you might not be aware of, and that is that Congress, for the last 8 years or so, has prohibited the use of federal funds to prosecute state-authorized medical marijuana programs. Congress has done this through a rider, an amendment to every funding bill that has passed since 2015, and that bill prohibits the Department of Justice from prosecuting state medical marijuana programs that are fully authorized by state law. Now, that rider is routinely reauthorized every year, and we expect that it will be continued to be reauthorized as we go forward. That rider does not impact recreational use laws. It is limited to state-approved medical marijuana programs. The effect of this rider has led state courts to conclude that there is some ambiguity in Congress's handling of marijuana because it limits the ability of the federal government to prosecute medical marijuana programs that are authorized by state law. So the existence of this rider has allowed numerous state courts to carve out from the otherwise broad federal prohibition some allowance for their own state programs. So that's what we're often seeing state courts do in light of this federal rider. So that's the current status of marijuana on the federal landscape. But there are changes that are on the horizon. So in October of 2022, the president issued a statement on marijuana reform. He announced in that statement that he would be pardoning those convicted of federal marijuana possession offenses. That's a very small number of people. But the more important aspect of that statement was a memo to the Secretary of Health and Human Services and the Attorney General, directing them to expeditiously review, and that's a quote from the order, to expeditiously review the Schedule 1 placement of marijuana under the Federal Controlled Substances Act. The Controlled Substances Act allows the administration to change schedules for particular drugs. And there have been numerous petitions to the Secretary of Health and Human Services and the Attorney General to deschedule marijuana entirely, or at least to reduce it from Schedule 1 to Schedule 2 or Schedule 3 or 4. All of those petitions have been routinely ignored by those federal departments. But in October of 2022, the president directed the heads of those departments to expeditiously review the status of marijuana as Schedule 1. Now, it did not direct them to take any action, and we have not yet seen anything come out from HHS or the Department of Justice in terms of rescheduling or descheduling marijuana. There is a complex administrative process that there are numerous steps that would have to go through in order for marijuana to be removed from Schedule 1, but it is possible to do that on an administration-only decision without Congress getting involved. Of course, Congress can always get involved, and there are numerous proposals in Congress to move marijuana from Schedule 1 in various different forms and under various different conditions. So we put up a link in April of this year. A leading Republican member of the House from South Carolina stated that the Speaker pledged to give her bill on marijuana legalization a vote in committee. That same bill has generally been passed, I think like 2 years ago. So there is some support in the House for that type of legislation. We have not yet seen a committee vote, and that legislator has not actually introduced the bill this session. So we don't exactly know where things stand in terms of what Congress will do. But Congress has the right to get involved at any point. They don't need to follow an administrative process or do any studies that the administration would have to do. And they can pass it and add it to any bill that passes both houses of Congress and gets the signature of the president. So all of this is contingent on maybe federal law might change, and it might happen sooner than you think. Because Congress works in mysterious ways. And so we don't exactly know if federal law will change, but it might. So that's the kind of the first caveat and thing to be aware of in terms of the current legal landscape. The states have not waited for the federal government to change its mind, and they have engaged in a robust series of changes to their marijuana laws. So we put up a map here. The states as of June 30. 23 states and DC have fully legalized marijuana for both recreational and medicinal purposes. 13 states have just approved medical purposes, and the rest are generally pretty hostile and don't have authorized medical marijuana or recreational programs. Most of the other states do allow for low THC products. Those are products derived from hemp that would not get a user high and would not produce a high and are specifically carved out from federal law. But otherwise, those states don't generally have medicinal or recreational use laws and possession of marijuana is still a felony. I love this chart because it changes all the time, so it may have even changed over the last 2 weeks. And it also implicates the concerns for employers who have employees or operations in multiple states. We are at this point, with where federal law is, no longer in a realm of a one-size-fits-all policy. For those with operations in multiple jurisdictions, they may be facing different scenarios depending on where they have employees, and actions that may be legal in one state or may be authorized in one state may be completely prohibited in another. So that means challenges for employers in terms of what policies they enact and how they handle employees in different situations. It adds to the complexity because state laws change and state regulations change a lot more frequently than they would on the federal level. And so it's important to make sure that you are mindful of what state you're in, what state the employee is in, where your operations are, and those sorts of concerns whenever you're addressing a medical marijuana in the employment space situation. And again, these laws are actively changing. Nebraska is one of the most hostile states to marijuana legislation, but in fact, 3 years ago, the people there passed a constitutional amendment to allow medical marijuana in Nebraska, much to the dismay of all of the elected office holders in Nebraska. That amendment was stricken down by the state Supreme Court a couple of years later, and there are other efforts now to put a new series of amendments on the ballot, which the people have already approved before, that would authorize it. So you're seeing changes, outside of office holders on the state level, and it's only a matter of time before some of these states that are in gray, I think, end up turning to light green or to a darker green situation. So let me go through some of the current trends. Each state has its own nuances, and so these are general traits that we are seeing with medical marijuana programs as a whole. Not every state will necessarily have every condition that you list on here. But these are generally what we see from medical marijuana programs that are authorized under state law. Usually there's a requirement for a physician prescription, continuing care from a physician, some sort of certification from the physician that the user has certain medical conditions that warrant the need for a marijuana prescription. Often states have some sort of identity card that will indicate that the user is an authorized possessor under a medical marijuana program or has received the appropriate certification. States will often put limits on where you can purchase medical marijuana, how much of it can you have. There are usually a lot of localized restrictions in terms of where dispensaries can be placed and how many people can be there at once, how large they can be. So there are lots of different restrictions that will apply to medical marijuana programs. Some states go so far as to restrict even the types of medical marijuana that are authorized under state law. So in Pennsylvania, for example, its medical marijuana program doesn't allow the smoking of marijuana. It allows only other forms to be used. Other states don't have those sorts of restrictions. Some states prohibit home growth of marijuana. Other states allow it. So there are varieties in terms of how states will authorize these programs, and what can actually happen in each individual state will depend on the law and the regulations that are enacted in each of those states. Usually you'll see a state control commission, so to speak. It's different names for different locations, but usually a state authorized governmental entity to oversee the licensing, the approval, registration, the cards. Those entities often are charged with enforcement of the laws in general. And that implicates an employment space. We've seen some courts say that only the state agency can enforce employment restrictions that are contained in the medical marijuana law. Other states say no, employees can do it as well. So there is a lot of variety in terms of medical marijuana programs that are out there among the several states. And just as there is variety on the medical marijuana side, there is perhaps even greater variety on the recreational use side. I have not seen any state that is under age 21 for purchase. All of the states here in the US, I think, are 21 or older. Canada is 19. So whether or not some states may change that, we'll not know. But it's usually a minimum age of 21 for purchase. States have very strict laws on the transportation of recreational marijuana or marijuana at all across state lines. That is one of the issues that will get the federal government quite upset. And the rider that I talked about earlier, which prohibits federal funds for the enforcement of or prosecution of state authorized medical marijuana laws, specifically carves out the interstate transportation of marijuana. That is still strictly prohibited under federal law. There are no restrictions on the federal government's ability to enforce laws prohibiting the transfer of marijuana across state lines. And as a consequence, states are very clear when they authorize recreational marijuana uses that that authorization is limited to the state's borders and cannot be transported out of state. For a lot of states out in the West or where there's a larger land area, that's perhaps not so much of an issue. I'm living now in Philadelphia. New Jersey is just across the river. New Jersey has a robust medical recreational use purpose that Pennsylvania does not. So those sorts of issues can create complications and can create complications for employees who may get caught violating one of those aspects of the laws and then end up in a situation that makes them unable to perform work or at least tied up legally for a period of time. Other trends that we see with recreational use laws are cash-only transactions. There are numerous bills in Congress that try to loosen federal regulations against federally regulated banks from servicing marijuana businesses, which are, again, of course, illegal under federal law. Those bills have a lot of support, but they have not actually been enacted yet. And so especially large banks are very hesitant to engage with marijuana businesses. Visa, MasterCard, very hesitant to authorize the use of their cards and their networks for marijuana businesses. So we'll usually see cash-only restrictions for recreational use programs. Once again, we see a common restriction in terms of the limitations on the amounts that individuals can use or possess or buy at any one time. Some of the recreational laws will have explicit protections for those who use recreational marijuana in terms of their employment. Usually there's a carve out for police officers or firefighters, but other than that, some states that include those protections in their recreational use laws say you cannot, an employer cannot take an adverse action against someone who is using laws in accordance with this statute, so long as that person's not using it at work or not impaired at work. Other states are less clear about the protections that are offered to users of recreational marijuana that are authorized under state law. A couple of states have what's called lawful off-duty statutes, which say as long as an employee is engaging in a lawful activity off-duty, the employer cannot take adverse action because the employee has engaged in that lawful off-duty. This came up in Colorado, which started the trend of state legalization of marijuana. Colorado has a lawful off-duty statute, and an employer terminated an employee for using recreational marijuana in accordance with state law. That employee sued and said, hey, that's a lawful activity in Colorado. I was off duty, you can't do that. And the employer said, well, it's still illegal under federal law. So no, it's not. And that went up to the Colorado Supreme Court, which said, as long as it's lawful under state law, then it's lawful off duty for the Colorado statute. So sometimes we'll see those statutes get applied to medical marijuana situations. And again, that's a state-specific issue, so something that you'll have to address on an individual basis, depending on where you have operations, where you have employees, and what situation faces you directly. All right, so now let's talk about employment-related issues. There are a lot of them, and I've already given you a preview of some of them. So we'll touch on a bunch of the trends that are here, but there are lots of situations where these questions come up, and we can only kind of touch on the basics here. The kind of first and golden rule is employer rights are going to vary state by state. That is an ongoing theme throughout this entire topic. Because this is all driven by state law at this point, there is not going to be a uniform rule, and what is legal or what an employer can do in one state is entirely different from what an employer can do in a different state. This poses challenges not just from the creation of policies, but in terms of training of supervisors, training of HR personnel in different states. A company may have to treat someone doing the exact same job in one state differently from someone doing the same job in a different state. So that is just something to keep in mind. All of the states permit an employer to prohibit employees from being under the influence of marijuana at work. Some states go so far as to enable the employer to specifically prohibit the possession of marijuana on an employer's premises or parking lots or lockers or anything like that. Part of the problem, and we'll get to this later, is there isn't a good current test to identify active impairment. And so the tests that are currently out there really focus on use over a period of time. So it is difficult for employers to rely on simply a positive test to show active impairment and to get the benefit of state laws that say an employer can prohibit an employee from being under the influence of marijuana at work. Most states have an explicit carve out for employers to permit testing or to take adverse action against employees who have tested positive for marijuana if necessary to preserve a federal grant or a federal contract. States generally don't like to give up free money and don't like to make it more difficult for employers to obtain federal contracts and federal grants. So to the extent that there is a federal contract or grant in your operation or your organization, and that the terms of that contract or grant require a certain testing protocol or certain adverse actions in the face of positive tests, that may be a carve out from your state's specific statute and give that organization a different answer than might apply in general to others. All states allow exemptions for positions that are governed by federal law, and that's an important thing to keep in mind. It comes up most frequently, at least in my experience, with commercial truck drivers, commercial licensing, CDL licensing, those driving commercial vehicles that are governed by Department of Transportation regulations. There's a specific drug and alcohol policy that applies to those positions, and random drug testing is one of them, and marijuana testing is part of that. And positive tests have certain requirements and restrictions based on those protocols. For those positions that are governed specifically by a federal law, state medical marijuana or recreational use laws generally do not apply. The federal law will trump that. So even if a state law says you can't use a positive test to take an adverse action against an employee, if that person is holding a commercial driver's license and is driving commercial trucks, the federal government will say you will have to, and that federal government rule will trump the state law rule. So we see that a lot with CDL drivers, but there are other scenarios and other positions that are covered by federal law. A lot of aviation workers are covered by federal law, a lot of railroad workers covered by federal law. There is a pipeline and hazardous materials safety administration that governs the use of pipelines and liquefied natural gas. Pipeliners that are covered by that administration are specifically covered by federal law. So it may come up in more scenarios than you're thinking of, but they are all covered by a specific statute or regulation. So there is a known identity of what those positions may be. So some states have a specific carve out for what's called safety sensitive positions. Unfortunately, far too few states actually define what they mean by safety sensitive positions. Only a couple do. Oklahoma does, New Mexico does, Iowa does, Pennsylvania roughly does, and has a specific section in its law for the types of work that someone can't be at risk of being impaired for, essentially, so that you can remove work from someone that you know is authorized to use medical marijuana if they fall into this particular category. Arkansas allows an employer to designate what safety sensitive means for their organization. And so the employer in Arkansas has a lot more leeway to say, well, this is safety sensitive in our view, and so therefore you can't be a medical marijuana user or user of marijuana if you have this position. Other states are a lot more vague about what safety sensitive means. And so once again, employers will have to consider what duties an employee does, where the employee performs that duty, what is the risk to the employee, to the product, to the public, to the coworkers. There's a lot that will go into determining whether or not an employee is in a safety sensitive position in those states that don't specifically define what they mean by that. And some states permit an employer to prohibit those who test marijuana from certain positions. Other states won't let you do that. So again, it's a state-specific issue in terms of what rights the employer will have for any given employment situation. On the employee side, again, state-by-state question. Some states will prohibit employers from considering a positive test result alone to be indicative of active impairment or a basis for discipline. New York is the first state that comes to mind with that sort of restriction or limitation on an employer's ability to use a positive test. A positive test alone is not a basis for discipline in New York State. Other states follow that type of rule. Some states go the other way and say that a positive test is something that can be considered. And so there's wide variety in terms of how states will give protections to employees. Some specifically allow an employee to have a right of action to sue their employer. Other states don't and will limit that right of action to the state entity in charge of marijuana for that particular state, or we'll just say that employees have a right, but they don't have a right to go to court. And so maybe state legislatures will get involved to change that, but in those states that said there's no private right of action, then an employer may consider that it has a little bit more leeway because there's less of a risk of a lawsuit at the back end. We've seen some states even allow localities to make restrictions on pre-employment testing. Some states have overall restrictions and some localities do as well. So New York does not allow pre-employment testing for marijuana. Philadelphia does not allow pre-employment testing for positions inside the city of Philadelphia, but Pennsylvania otherwise allows it. Nevada does not allow pre-employment testing for marijuana. So different states will have different rules in terms of even what you can do for pre-employment testing for employees or applicants. And most states will generally prohibit an employer from taking an adverse action against someone simply because they have the status of a medical marijuana user. Simply having the card is generally not going to be enough to take an adverse action. And that on some level makes perfect sense, right? You can have a card and just not ever actually use it. And so states say, well, you can't just penalize someone for going through the process and getting the card. And so that general prohibition and protection is around, and we'll see that for most states that authorize this type of program. One of the big concerns for all of this is disability discrimination and how employers face and handle situations where an employee or applicant is tested positive for marijuana and says, well, I have a medical marijuana card and you have to let me use marijuana now. And it comes up in lots of different forms. Couple of things to keep in mind when you're facing this type of situation. First, as of right now, given the status of where federal law is, the Federal Americans with Disabilities Act doesn't apply here. That law specifically carves out individuals who are currently engaging in the illegal use of drugs when the employer acts on that basis. And again, as of now, marijuana is illegal under federal law. So the courts have been very consistent that the federal EDA does not apply to provide protections for medical marijuana users or recreational marijuana use because it's illegal under federal law and there's that carve out in the EDA. For states that also have that same carve out, that follow that federal ADA definition, there would be a similar result in those jurisdictions because of the current use of federal law of illegal drugs. But again, that can be a state specific rule. Like in Colorado, the Colorado court said, well, if it's legal under state law, then we're going to count it as legal here. So something to keep in mind. But in general, the federal ADA is not going to apply here, which means, of course, that it is a state by state rule, and that has its own complexities and issues for wherever you have employees. The states run the gamut in terms of the protections that they offer to employees who want to claim a need for an accommodation on the basis of disability because of their use of marijuana. Some specifically say there can be no adverse action against an employee because of the use of medical marijuana or a positive test result that results from their use of medical marijuana, as long as they're not actively impaired at work. Other states have said that an employer does not need to make an accommodation for medical marijuana uses, either in general or under most conditions. And a surprising number of states have done that. California did that, and that's currently the law in California for the next 6 months. But the governor just signed a bill to change that law effective January 1, 2024. So states are changing that sort of rule, but we've seen that in a number of states, specifically out in the West, that said employers don't need to make accommodations for medical marijuana usage for their employees. Other states, of course, go the other way and say that an employer does have to make and provide a reasonable accommodation for employees who use medical marijuana or marijuana off duty, so long as they're not impaired at work. And so in order to really address this sort of situation when it comes up, you have to think about what are the essential functions of that role and position. Does the use of marijuana or an exemption from the employer's policy that says you can't use marijuana, or you can't test positive, would an exemption from that general rule still allow that employee to perform the essential functions of their position? And that individualized inquiry, that inquiry first should be individualized. It should be individual to the person, the role, the job, and the state. And you can see why there's a need for that, right? So a receptionist who has a medical marijuana card and uses marijuana on a Saturday afternoon once a week and is otherwise answering phones and doing receptionist duties, is not impaired at work, maybe there should be an exemption for that person, because the use of marijuana, though it may result in a positive test on Monday, doesn't actually suggest active impairment, and there isn't anything in that person's duties that would suggest that that person can't perform the essential functions of the receptionist job. Maybe that's an entirely different answer for someone who's driving a forklift with pallets of material in a warehouse. And so this is an individualized inquiry in terms of the disability discrimination piece. And it's going to require, specific attention to the duties, the position, and the state. A key complaint I often hear is from employers who don't want to make an accommodation for allowing someone to smoke marijuana. And usually that complaint comes in and smoke marijuana at the job or at the work or, in the lunchroom. The disability discrimination piece and the reasonable accommodation requirement comes from an accommodation to exempt employer policies because of an impairment, a disability that qualifies under the law. So it's not so much an exemption just because someone wants to smoke marijuana. That's generally not what we're talking about. It comes up in the context of someone who has a disability that would qualify them under the statute, and their request for an accommodation is something specific about being exempted from a particular policy in order to enable them to do the functions of the job. So there are a couple of different steps that go in, and it's not simply now I have to let everyone smoke in the office. You don't have to do that. And that's kind of where the individualized inquiry will be really helpful for employers here. So I have been talking for a lot. This will be the last one I talk about for right now. Workers' compensation, the general theme, of course, is this is going to be a state-by-state issue, and this law is changing all the time. Pennsylvania's law on this just changed 2 or 3 months ago, and there was thought that it may change again if that case got appealed. So some states will require workers' compensation insurers or employers to reimburse employees for medical marijuana usage. Some states will prohibit insurers from doing that. And I have not seen any state that requires the employer or insurer to actively purchase the marijuana themselves. And that would technically be a violation of the law. But so it comes in the reimbursement part. Is this a reimbursable expense that would otherwise be covered under a workers' comp law? And states are taking different answers to that question. A lot of workers' comp laws feature an exemption of coverage for those who were actively impaired with alcohol or drug use at the time of the accident. And states, again, run a different gamut in terms of whether or not, how they will assess active impairment when someone tests positive for marijuana. This usually comes up in post-accident testing. And so it raises a whole boatload of issues that are better handled by my colleagues doing workers' compensation. But again, it's a state-by-state process and usually involves an interplay of the carrier, the insurance law, the workers' comp law in each individual state.
Thank you so much, Jason. We'll come back to you, so don't go anywhere. I wanted to touch briefly on something y'all might also be wondering about, and that might be, what about coverage under our employer-sponsored health plan? Can individual participants seek reimbursement for medical marijuana under those plans? It's a little bit of a question as to whether or not your plan is fully insured or self-insured. As Jason mentioned before, despite legalization in these states, it's still classified by the federal government as a Scheduled I drug that, quote, has no currently acceptable medical use for. And then, on top of that designation as a Scheduled I drug, each plan, in order to have coverage for a drug, has a drug formulary which lists out the medications that are covered for plan participants. And it would be very unusual for a carrier to agree to list a drug that has not yet been approved by the FDA. And with its status as a Scheduled I drug, it won't be scheduled or be approved by the FDA in its current classification. So under a fully insured plan, there's not going to be an avenue for coverage or for reimbursement to the plan participant for that type of medication. Now, if you have a self-funded plan, there might be an exception. It's not subject to the same federal rules, with the exception of ERISA. It's mandated by, governed by ERISA rather. Employers would be free to offer medical cannabis coverage, understanding that there is some risk associated with this, not unlike the risk that might also be associated with the abortion coverage that some employers extended in the wake of the Dobbs decision, allowing employees to travel to a different state to obtain a legal abortion. Same kind of thought process there. It would be difficult to administer if you decide to do that, because again, as Jason highlighted, and I think that's probably the one theme you can walk away from, is that it is not a one-size-fits-all approach, especially if you have operations and employees in several different states. It would be difficult to administer, so just prepare yourselves for that, because what might be legal for an employee in one state will be illegal in a different state. And then the other piece to keep in mind, that despite whether or not, or regardless of whether it's a fully insured product or plan or a self-funded plan, there isn't going to be an ability to get reimbursement under some other tax favored accounts. So if you have an HSA, an FSA, a health reimbursement arrangement, those tax favored treatment accounts will not allow for reimbursement of this, again, because of its status as a Scheduled I drug. So it's maybe there's coverage, but there's definitely some challenges there and some things to be aware of as a plan sponsor. So at this point, we are going to turn it over to Mark and Marty Ann to talk about some drug testing, timing methods, and some challenges that employers face in that space.
Thanks, Krista. I'll start off and then turn it over to Marty Ann. I think I want to echo a couple things that Jason said. When we set up programs, particularly for controlled insurance programs, we always want to know what the state laws are and what we're allowed to do. It's very important to be in compliance with the state regulations. So working in states from Connecticut to Pennsylvania to New Jersey to Maryland, District of Columbia, Tennessee, and Florida, every state has little differences in their law. So one of the things we do is we work with our partners, third-party administrators. Our third-party administrators, such as Concentra with Marty and Martins here, we rely on them heavily to advise us on what we can and can't do. We also usually will have a legal counsel review our policy and procedures prior to implementing them to make sure we're in compliance with the state laws. And I can tell you that over the years putting together these programs, I'm surprised a lot of times by what states restrict you, what they restrict you from, and in certain instances, as Jason mentioned, the city of Philadelphia, what you can and can't do from a testing standpoint. But the reasons for testing, pre-employment, a lot of our controlled insurance programs, we test pre-employment. Certain states will allow us to do certain things, other states will not. One of the things that we typically have put in our pre-employment testing, and we do believe in second chances. So based on the owner, we will give somebody pre-employment since they're technically not an employee on the site yet until they have a negative drug test. We will permit second chances there, and we will permit somebody to test. We typically set a time period of 30 or 60 or 90 days from which they can come back and take the pre-employment test again. Reasonable suspicion testing. We see very little of that in the jurisdictions which we are in, but I do believe it's very important. For those of you who are GRAM clients and have access to our risk management center, there are two specific programs on there. There's a program on there, 1 hour, which I always recommend for crew leaders or supervisory personnel. And I think it's important that your supervisory personnel be trained on reasonable suspicion. There is no expiration date on that training. There's another program on there for those who are administering the program. It's about an 1.5 hour program for those who are administering the program. There's also outside resources. Concentra offers training, and I think it's important that we have supervisory personnel who are trained in reasonable suspicion. We do talk with our owners regarding random drug and alcohol testing. Some owners will do it, other owners will not. If they are going to do it, it's very important that this be random, truly random, and we rely on our third-party administrator partners to do the draw usually for random drug testing, drug and alcohol testing. Post-accident, we extend that to post-accident incident, injury, and near miss. We have had testing for near miss type situations on certain projects in certain situations. And I think it's important there that, what we talk about when we set up the programs is we do not do blanket post-accident incident and injury drug testing due to the memorandum that OSHA issued a few years back. What we do is we talk with our partners on site to make it clear in what situations we would require a post-accident incident or injury drug and alcohol test. An example of that would be if somebody falls off a ladder, somebody falls off a scaffold, somebody falls off or slips and falls on the project, somebody's injured due to lifting. Chances are we would do post-accident or incident drug and alcohol test But if somebody's walking across the site and gets dust in their eye due to windy conditions, chances are we will not drug and alcohol test that individual. Return to duty testing, we do believe in that, and we do usually put that language into our programs. That gives somebody who has tested positive and has received employee assistance program, an approved program, they come back to duty, and we would test them prior to returning to duty. And of course, we all have Department of Transportation requirements, and it's very important to partner with your third-party administrator so you're fully familiar with the drug and alcohol requirements for Department of Transportation. Those clients that fall under that. A couple other things that we put into our language in the programs. We learned many years ago that it's not only smoking, but it could be vaping, it could be e-cigarettes and things like that. So in our programs, typically we will put language in there prohibiting smoking, vaping and e-cigarettes on projects. E-cigarettes not so much, but the vaping became an issue with one of our clients in Connecticut, and we wanted to make sure that we address that going forward. So that's a standard language in our programs. We've also put into our programs fit for duty evaluations. I'll give you an instance on that. We had a supervisor who was on pain medication for a back injury, went through the drug testing process and came back positive. There was a note from the medical review officer who's employed by our third-party administrator, a note, basically telling us, with the positive drug test, he did have a legal prescription for the pain medication. What we did is we set up a medical evaluation by a reliable medical provider, and let the medical provider determine if that person could work based on the job description, based on the type of work, based on the medication, and the recommendation from the personal physician who prescribed the medication. So I think it's important to have things like that in your program. And with that, I'll turn it over to Marty Ann.
Marty Ann, before you jump in, I just wanted to point something out. One of the things that you highlighted, Mark, was the being able to train your boots on the ground personnel to identify impairment. We will talk about this a little bit later at the end of the presentation in terms of best practices, but New Jersey has put out a form. New Jersey now requires an observation in addition to a positive drug test in order to take an adverse action. And the form that they've put out, it's generally very good. I mean, it helps you identify things that might be outward symbols of impairment, and it really walks somebody through a full assessment of an individual. And so we will post that and we will provide that to you all in an email after the presentation. But I really encourage you, when you're thinking about developing a program in consultation with your outside counsel, to look at that and look at that as a resource for your team and your supervisors to help arm them with the information that they need to be able to substantiate their observations. And it helps bolster any adverse action you might take in the face of any kind of litigation. So I will turn that over, unless you have something else to add, Mark, I will turn it over to Marty Ann.
I think one of the other things Jason mentioned that might have gone under the radar is the safety sensitive language that certain states have. And we have used that to our advantage when putting together drug and alcohol testing programs. So again, the research that goes into it and making sure that if a state or a local entity such as Philadelphia has safety sensitive positions, language in there, that you use that to your advantage when you're putting together drug and alcohol testing programs.
So thank you for kicking it over to me. My section, I'm going to talk about some drug testing comparisons. And but before I go into that, what I wanted to mention is we had talked about the medical review officer, and Mark had given an example of a result that came back as positive, even though the person had a medical marijuana certificate. Medical review officers fall under federal regulation. So when they fall under federal regulation, because federally marijuana is against the law, it doesn't matter what your state regulations are when it comes to medical marijuana or recreational marijuana. That test is going to report back as a positive until the legislation changes. So that will report back as a positive. The medical review officer will ask the employee if they have a medical marijuana certificate. If they do have a medical marijuana certificate and want to divulge that to the employer, then the medical review officer will add that note in. So always definitely double check your positive tests if you've got legislation where medical marijuana is okay, and depending on what state you're testing in. So I just want to make sure that that is really clear. Of the different types of testing, there's about 6 different types of testing on the market right now. We're going to go through 5 of them, but with those drug testing methods, they're all very, very different. And I don't know if everybody always realizes that, but they can vary based on the type of test. So you've got the lab urine testing, which that means it's collected at the clinic and sent out to the lab. A lot of times people get confused and they think the clinic is the lab. The clinic is not the lab. The clinic is the clinic and then it goes to the lab. So there's the lab urine testing. Usually this collection can take about 15 to 20 minutes, depending on if that person can provide a specimen. If they can't provide a specimen, golden rule is to allow the person to sit there for 3 hours, drink some fluid until they are able to provide that specimen. Turnaround time of that is usually 24 to 48 hours when it's received at the lab. All specimens are overnighted to the lab. Of course, they're overnighted. If it's a collection that's done on a Friday, it's going to be overnighted and it's going to be received on a Monday. So keep that in mind when you're looking at these turnaround times. Urine collection is allowed in every state. The lab version, it's DOT approved. All DOT tests right now are urine collections. They're being sent out to the lab. They're lab-based tests. And with these lab-based tests, there are custom panels that can be made. So a lot of times I have clients that come to me and they might be on a job or they're hiring for a certain, maybe a hospital or a certain position, or they're on a contract and they need to do a certain type of test. With the lab-based urine testing, there are custom panels available, so we can create those tests. The thing with the lab-based urine testing is it can detect only several hours after use. So if you have somebody who literally does drugs right now and you send them for a test, it's not going to show up if it's not that you send them, a couple hours later. So there is a recent use lag time when it comes to the lab-based urine test. With the rapid test, so that's often referred to as POCT, which means point of collection testing. Any regulation, state regulation, it's going to be referred to as POCT. So sometimes people don't recognize that. That is a test that's being collected at the clinic, and usually it's being read at the clinic. Sometimes it's by a machine, sometimes it's by a person, depending on what devices the clinic is using for the point of collection testing. Collection time is 15 to 20 minutes. Turnaround time for those drug test results for a true negative is 15 minutes. If it has to be sent out to the lab, it's going to follow exactly the lab-based urine testing procedure. This test is not legal in all states. It's not legal in some states for certain reasons. For instance, in North Carolina, you can use it for pre-employment testing, but you can't use it for post-accident or reasonable suspicion or any other reason for test. So this test, when you're a client that is multi-state or multi-market, what we would refer to at Concentra, we need to make sure that depending on the states that you're testing in, that you're doing the appropriate test for the appropriate reason for test. These are fixed panels. You cannot change the panels, and I'm going to go through the panels on the next slide. So you can't make up a rapid test. It is what it is. The cup is fully loaded already and tested based on what that cup was made for. And with this, it's the same thing several hours after use. So if you have somebody doing drugs in their car, you see them, and you send them right away. If it's the first time they've used it, it's not necessarily going to show up if you just caught them now. And then there's the oral swab fluid testing. This is a big deal. Oral swab fluid, there's some new legislation that just came out from the Department of Transportation. We're very excited about this, but they're going to start allowing oral swabs to be used. The legislation came out on May 2nd, 2023. They're saying that we're going to be able to use this oral fluid testing as an option. The big deal and why it hasn't been rolled out yet is because we need to have devices, so that nobody wanted to make a device until it was approved. So now that it's approved, devices can be created, and then 2 labs have to be authorized by the Department of Health and Human Services to be able to do this testing, which they can't be authorized until they actually have a device to do the testing, because there's that split specimen component. There's also going to be collective training that goes along with that. Whereas right now with the non-regulated testing, you can train your employee in some states to just be able to do the test. So that's going to be a little bit different, and we're all very excited about that. They just passed this legislation because a couple things. It decreases the ability to adulter the specimen. It's an observed collection, so it's going to be, tested right in front of somebody. The device is super simple, which makes it great. Also, there's a cost saving. So instead of having, a DOT driver or having an employee leave the place of work, go into a clinic, take the time to do the test, and then return back to the job. These are tests that are going to be able to be performed right on site. And Concentra is going to be able to offer these tests. So that's very exciting. The collection, clinics can do the collection, supervisors are going to be able to do the collection. They can be sent to the lab, just like a lab-based test. It takes about 20 minutes. The reason why it takes a little bit longer is because that person, they cannot have anything in their mouth 10 minutes prior to doing the test. So they can't drink water, they can't have anything to eat, they can't chew gum. So we have to have that observation time to make sure that the test is valid. Those results, 24 to 48 hours after it's received at the lab. These, again, they vary by state on whether they're legal. Maine, Vermont, and Hawaii right now, in those states, the oral swab fluid testing isn't legal, but with it becoming federally legal for DOT, we think that the legislation in those states is going to follow right after. This is, again, going to be fixed panels. You can't change the device. You can't have a custom panel. And this can detect within minutes after use. So that's a big difference from several hours. This is minutes after use. So this is a very exciting product that's coming out. And then, of course, you have the lab hair testing. This is collected at the clinic. It's always sent to the lab. It's a piece of hair that has to be collected. It's put in like tin foil, and then it's sent out. This is usually 5 to 10 minutes. The only trouble with this test is that sometimes people come in and they've shaved their whole body, they're bald, and then you have to find alternate places to get hair off of the body, or we have to call the company and find out if we can do a different method of test. Turnaround time is 24 to 48 hours. Legality varies by state. Jason was talking about, all the different states and all the different laws. It's the same thing with this. These laws vary drastically by state. Not approved for DOT. You can only have fixed panels. It detects 7 to 10 days after use, but it gives you that 90-day window. And then there's lab blood testing. Lab blood testing is very uncommon. I don't see this very often. I think the only state I've seen this done in is Nevada. It varies depending on the collection, the collection time. So, if the person's dehydrated and they try to get blood, it could take a little bit longer to be able to do that venipuncture. Results are 24 to 48 hours, and generally they're not permitted in workplace testing. I had somebody call me from Maryland that wanted to do this like 2 days ago, and I was like, no, sorry, you can't do that. Not approved by DOT, and custom panels are available, of course, and results are within minutes after use. Lab blood testing is generally done in the emergency department. It's a post-accident. They want to find out, can they give them medication? Do they have something already in their system? That's really where you're going to see that lab blood testing done. Next slide.
Marty, and before you move on, could you give the viewers an idea of the costs associated with these types of tests?
So costs vary. At Concentra, my department, we price things out based on volume. So drug tests can vary, and it can also vary by panel type. If we're doing a drug test with fentanyl in it, it will cost more. Lab-based hair testing is generally around $100, and that's a fixed panel that can be done. Oral swab testing, I think at the clinics right now it's around $122, but again, through my department here at Concentra, it's based on volume, so we're able to do better pricing there. And same thing with the lab-based urine the rapid test. You know, that all depends on the client's volume. A large volume client can get better pricing than, of course, than a smaller one, because we can ask for better pricing. Yep. All right, on the next slide. So substance detection time frame chart. So depending on the type of test that's being done, it will determine how long of a window that person may have had that in their system. So with this focus, we're talking about THC cannabinoids. So that's up to 24 hours for the oral fluid. So that person could have taken it anytime up to 24 hours. With urine, it's 2 to 3 days for light smokers and 5 days for moderate, 10 days for daily smokers, and 28 days for chronic smokers. That's how long it can stay in the system. So sometimes we'll get somebody who, you know, smokes once in a while. It may not necessarily show up if they're once in a while. And then blood is up to 2 weeks, and hair is up to 90 days. So a lot of times we'll see hair testing being done with like police departments, where they're trying to make sure that that person has, you know, they have set a precedence where they're not using anything. That's normally where I've seen hair testing done, corrections, police, in that area. And then, you know, what's important is when I'm talking to customers is, you know, that some customers will say, well, I give them 5 days to go. Well, 5 days to go on a drug test is too long. That's too long of a time frame, because when you're giving that person that 5 days, that's 5 days to get all of the stuff out of their system. So if they use cocaine and you give them 5 days, more than likely you're not testing for cocaine anymore, because they're not going to take it anymore. So I always try to tell employers, you know, keep that window of time, you know, 24 to 48 hours, give that employee to go in and have that testing done. The better, you know, that 24 to 48 hours is that better time frame. Next slide. So with drug testing, there's a lot of issues. We've been seeing a lot of employers, you know, taking it out, but we're seeing a spike, a huge spike in positive tests. So with drug use, it represents as much as a 5-fold increase in workplace injury claims. So, and that's drug use across the board. But THC is the highest group of positives, you know, with any lab right now. Up to 50% of all workers' compensation claims are related to workplace drug abuse. Substance impairments may lead to 3.5 times more accidents. There was an incident that happened between a Amtrak and Conrail, two trains, where there was an incident that happened where they collided. In that particular incident, 14 Amtrak passengers and 2 employees were killed. With that, 174 other people were injured, and the cause of the accident was excessive speed and lack of attention. The Conrail engineer and the Conrail brakeman both tested positive for marijuana and PCP. The Amtrak engineer that passed away tested negative. So with these safety sensitive positions, this would have fallen under, you know, FRA, Federal Railroad Association or Administration. With this, you know, the federal government is definitely looking at these DOT drivers, FMCSA, all these different modes, and they're not going to take marijuana out of there. They might change the class of it, the schedule of it, but for these safety sensitive positions, which of course, you know, you wouldn't want your air pilot to be high on THC. But with these safety sensitive positions, they're going to keep that in there. That's not going to change for the Department of Transportation. That particular accident with Amtrak and Conrail cost $58 million. So 2 employees that were high caused this horrible incident to happen. So substance abuse can increase 2.5 times the likelihood of an employee missing 8 or more work days. Pretty big deal. Substance abuse may contribute to productivity being 33% lower than it would be otherwise. With this, the Department of Transportation put in a FMCSA, that mode, put in a clearinghouse. They put it in 2020. Statistics last year, there were 166,000 FMCSA drivers. These are your tractor trailer truck drivers and your school bus drivers tested positive. Of that group, 77,000 tested positive for THC. And that's in 1 year. Of those, only 60,000 went through the substance abuse professional program. So there's 100,000 drivers out there that now can no longer drive under the DOT FMCSA mode or any DOT mode, and they're looking for work. So, you know, think of anybody who drives a vehicle. They may have been a CDL driver and now they're no longer a CDL driver. Those people are you know, looking for employment. Sometimes they go to smaller employees that don't know the DOT regulations. Sometimes they go and they, you know, drive a smaller box truck. But, you know, those are big numbers. Those are big numbers. And those numbers are just going to go up with the oral swab being introduced because it's an observed collection. Next slide. So what are we seeing? Just like everybody else is saying, laws change literally every day. They change constantly. The best bet for anybody who has Department of Transportation folks is to sign up for the newsletter. You'll find out what's going on. You'll be up to date. You'll know what legislation is coming up. When it comes to your policy, I would review that regularly. You know, bring it to your legal counsel, have them review it. We're seeing a huge shift in testing. A lot of employers are taking THC out, and it's not necessarily due to state legislation. It's more lack of knowledge about their state legislation and their rights as an employer. So I would definitely seek legal counsel and, you know, find out what are your rights as an employer, because you may be able to test if you have safety sensitive employees. It all comes down to, you know, the laws that are in your state and your policy. You need to make sure your policy is ironclad. We're also seeing a big shift in the inability to hire workers due to positive tests. This has impacted the Department of Transportation huge because now there's, you know, 100,000 drivers that can't drive. So we're seeing this a lot. We're also seeing employers waive the marijuana, not test for it anymore, specifically so that they can hire workers. You know, they're willing to take on the risk, essentially, to be able to get somebody in the door so they can have production. But we're seeing a lot of positive post-accident tests. With the marijuana wave, this has been happening, geez, probably 6 years, this marijuana wave, and you're seeing that legislation change. You know, that chart, the chart of the United States shows you how that marijuana wave has been impacting across the country. California and Washington have just passed this legislation now that you can no longer in those states test for, or you have to exclude non-psychoactive cannabis metabolites. So of course, us at Concentra, we're like, okay, what test can we do that with? That's the oral swab. The oral swab meets that. So in those states, you're going to see a shift, except for your DOT people, your non-DOT, you're going to see that shift over to the oral swab in those states. And then there's some new non-invasive testing methods that are coming out. There's a new breath test that's coming out that's going to be able to test for marijuana within for past 3 hours of usage. That's going to be a big deal when that becomes available. So 3 hours is not a big time, it will show impairment. And that's the biggest problem that we've been able to have. It doesn't, the tests that we have right now do not show impairment. This will show if the person is used in the past 3 hours. It's going to be a lab-based test right now. They're working on coming out with a rapid test as we speak. But this is changing. This is going to change the market drastically, this product. And it also will meet that non-psychoactive cannabis metabolite where it has to exclude that. So that's pretty exciting stuff we have going on. Next.
So I think we're going to turn it over back to Jason to talk a little bit about, you know, now that we have all this, what kind of policies do we have in place, or what are some of the lingering questions that employers might have with this as the context or point of reference for them?
Sure, thank you, and it was great to hear from Mark and Marnie-Ann. Lots of questions here, so I'll toss in a couple and share some thoughts and toss in some best practices as well. First kind of question, does it make sense to do pre-employment testing anymore? For some employers, I think the answer may be no. For other employers, the answer is wholeheartedly yes. And so each employer is going to have to make that decision based on the personnel they have, the duties they have, the risk to other employees and to the public and to their business model. For some workforces, it may be mandatory for a portion and not for the entire workforce. Some employers are facing difficulty with attracting qualified applicants, with retaining people who are there, and they may make the decision not to test, or not to test in states that have recreational use, but to test in other states, or some sort of combination. There really is no one size fits all here. And the drug-free workplace that was the model of federal legislation 30 years ago is now really out of view for current employers, given the current situation that we have with all of the different laws. We haven't talked a lot about collective bargaining agreements and unionized workforces, but there are numerous restrictions involving the use of discipline or drug testing. That's a mandatory condition or subject of bargaining for those types of employers and those entities. And usually CBAs have a carve-out language for nothing in here will, impede the parties from following state or federal law. Nothing is meant to contradict federal law. In the event of a conflict, the law will trump the text of the CBA. So there are lots of questions that are, again, individualized to specific states and CBAs for how drug testing can impact the use on a unionized environment and what's permissible and what changes you can make depending on whether or not your workforce or the workforce that you want to test is unionized. We mentioned in the last point before, our supervisors trained and equipped to make observations that could indicate active impairment at work. Until the drug testing gets to the point where it can show active impairment, and it sounds like that is coming soon, but until we get to that point, a positive test itself is probably not enough. And even if it is enough, probably not the wisest course of action for employers to rely simply on that positive test result, because there were lots of explanations for why that positive test result came back as positive that don't implicate an employment situation or an active impairment. So the best thing to do is a little bit more work on the supervisors and managers in terms of making observations and training them into what aspects they should be looking at. Have a chart, that New Jersey chart that they put out, I do think is a pretty good workaround for employers to use right now, even though it may not be required where they are at, which demonstrates some of the common traits and behaviors of someone who would show active impairment and allows the supervisor to see if they're present and check off if they're present or not. It encourages the supervisor to get a witness and see if there's someone else who can make the same observations using that same form, so that the employer has a paper trail of observations from managers and supervisors who are saying, this employee demonstrated the following characteristics that made me think that he was actively impaired at work. And so those are where we're starting to see employers tend to go. A lot more training on the HR and supervisory side, and a lot more of a carving out of their actual workforce, where do I need the strictest oversight and policies? Where do I need the strictest supervision because the duties of those roles are so sensitive or so important to the organization or have so much more risk that I need to have a level of comfort that no one there is actively using drugs that may impair them days after the fact or that may impair them later, versus other positions where that level of scrutiny may not be required for what's actually happening. So lots of different ways that employers can go. And those are some of the trends and things that we are seeing in terms of kind of best practices for the future of the drug-free workplace.
So that is the pre-planned portion of the presentation. If anybody has any questions, feel free to drop them in the chat. I don't see any yet, but we're happy to answer anything that you might be thinking of now that you have this sort of frame of reference. If not, you can always follow up with us individually. Our contact information is here. Or as a reminder, just while we wait for some questions, as a reminder, if you are looking for any kind of PA CE or PA or New Jersey CLE, the form for credits is in the chat box. If you click on that, fill it out and hit submit, we will submit it to the respective crediting agencies. I don't see any questions yet. So with that, we will say thank you to Jason, to Mark, to Marty, Ann for your insights. Thank you for everybody for your attendance. Again, we welcome questions. Feel free to reach out to us. And with that, we'll just say on behalf of the Graham Company and all of these panelists, thank you so much for joining us and have a great day.
Thank you, Krista.